Now we go to House Bill 5471, sponsored by Terry Cortland. It's an act relating to motor vehicles and other vehicles, motor vehicle offenses. Terry, are you ready?
Yes, I'm ready.
It's all yours.
Thank you. Thank you. This bill would increase the fine for somebody that was arrested for DUI, drinking under the influence, or for refusing a breathalyzer in the amount of $300. And that $300 through FUTA would be targeted to the 8 prevention coalitions that serve our communities and our schools around the state. It's pretty simple. Senator Seveny has been working on this for years, so this is a companion bill. He's my senator from Portsmouth, and that's what the bill does.
Thank you, Representatives. Representative Cortland, do we have any questions of the sponsor? Seeing none, we'll call our first witness. Steve Brown, are you there?
I am, Vice Chair. Thank you very much.
Well, nice to hear from you. So you have the floor.
Thank you. Stephen Brown, representing the ACLU of Rhode Island. I'm here to express our organization's opposition to this legislation. Obviously, we don't oppose the idea of having more substance abuse education, but we are concerned about adding more fees and fines to individuals who are convicted of crimes. This is an issue that across the country legislatures are dealing with, recognizing that there's a real downside to continuing to impose larger and larger fines on individuals who've been convicted of a crime that just sets up a pattern of failure. They can't afford the fines. They can't come up with the money. They face consequences when they miss a payment or fail to appear for a court date because they haven't made the payment. And I think it's important for the committee to understand all the fines and fees that already exist in this specific statute. And I would refer you to written testimony we've submitted that goes over it. As you know, just when you're convicted of a crime, there are various fees that are imposed in the first place. But in this particular statute right now, a person who is convicted of refusal has to already pay a $500 highway safety assessment fine, a $200 chemical assessment fine. There's a general fine of up to $500 that is imposed. And then there are collateral penalties that cost money, such as the payment of fees if they're required to get an ignition interlock system. There's a required attendance at a DUI course that they must pay for, and so on. And under the statute, none of those fines can be suspended. So we just think that adding another $300 to the thousands of dollars that right now are imposed on an individual who's convicted of violating this statute just goes too far. And just, in many instances, it will never be paid, but it will prompt this individual to have to miss work, do all sorts of other things in order to try to pay it. So we'd urge the committee to look at other ways to pay for substance abuse education, but imposing this additional fee is not the way we think it should be done. I'll be glad to answer any questions.
Thank you, Steve Brown. Any questions from members of the committee? Seeing none, I believe we have Mike DiLauro. Who? Oh, Rep Knight, are you there?
I'm here. Can you see me?
Oh, yeah, there you are. Okay. You ready?
I wanted to, not so much a question, but I do want to take a moment to agree with the ACLU in this particular case. And I think it's worth noting that, our criminal law provides for a debt that someone has to pay for making a mistake, which created a danger for the public. And it is near impossible sometimes for people to get out from underneath the consequences of a DUI conviction. One, that they, in 99% of the cases, will plead to and accept responsibility and try to move on with their lives. It's also worth noting, Steve alluded to that it's a possible added cost, but I'm here to tell you as a practitioner that just about every case, DUI or refusal case that is resolved these days, usually involves an interlock, which is an additional substantial amount of money out of someone's pocket so they can be on the road and earn a living and drive. This bill, as well-intentioned as it is, seems like piling on when you look at all the other costs and fees that are in the statute. And I agree with the ACLU that we could achieve the goals of this bill, perhaps even by saying, let's just tack on $5 onto every controlled substances offense. You'd get there faster and not make it increase the instability in the lives of these people who, through their substance abuse problem, have already endangered the community. We want to make sure that those people get on the right path, not keep them from the path. So that's my 2 cents. Thank you.
Thank you, Representative Knight. Any questions for this witness? Yes, Representative Baptista?
Yeah, I'll just say very quickly, not to repeat too much of what has been said, but I agree with both Mr. Brown and Representative Knight. And just to make it very real for folks, when you're talking about DUI, and granted, the DUI is something very serious. We don't underestimate that. But the conversation I have with people is that you're looking at about easily $2,000 out of your pocket before even thinking about hiring an attorney, which can often be at least another $2,000. And so just wanted to put those specific numbers out there. It's a really difficult conversation to have with folks, and I appreciate the points that are made by my colleagues.
Thank you, Representative. Any further questions from the committee or comments? Hearing none, we're going to go to our next witness, Mike DiLauro. Where is he? Who's that?
Thank you.
Are you there, Mike?
Yeah, I am.
Welcome.
I am, Vice Chair. Thank you. Thank you for having me. Members of the committee, Chairperson McAtee, it's a pleasure to see you all and to hear you all. Wish we could be in person. So our opposition to this legislation has absolutely nothing to do with whether or not the program that these fees would fund, whether or not it is a good program that does good work. I remember meeting with Senator Seveny 2 years ago to talk about the program and did some research on it. So it's not about that. Our opposition to this is based upon the fact that it isn't a very good idea for a number of reasons to try to raise money using the criminal justice system or the court system. And those of you who have been here for a while have heard me talk about this many, many times. Those of you who are new will be hearing it for the first time. So let me just tell you that in 2008, the General Assembly enacted a comprehensive series of reforms that were supposed to change the way in which judges assessed and collected fines, fees, and court costs. Now let's peel off fines for a minute, because fines are a legitimate sentencing option in many cases for judges. So what I'm talking about really are these fees and assessments that are mandatory. The legislation that you passed in 2008, and coincidentally, I'm speaking at a continuing legal education program tomorrow for the Rhode Island Bar Association on this very subject, came about as the result of a report that you have. I emailed it to Ms. DeMezza this morning, and I'm sure you have it. That report from the Family Life Center, now Open Doors, found that the most common reason people in Rhode Island are put in jail is for court debt. 17% of all jailings and almost 2,500 incidents a year. 1/3 of those sat in jail for over 3 days, and 11% spent more than a week. And it goes on and on. And you know, this is the most troublesome thing for some folks. And, you know, for me as a public defender, obviously, it's the loss of freedom. But for folks who are dollar and cents types, the Open Doors report found that the total costs to the state are about $500,000 per year for incarceration of these defendants. So it's not a very efficient way either to raise money for the state by upping upping fees. And that's what this is. This bill is an attempt to raise money for what is a worthwhile program, but to use a system that was not designed to do this. In 2015, research started, and we found, guess what? We found that these wonderful reforms that you folks put in place in 2008, that our judges were not following them. And there was there've been a series of bills that have been filed to try to fix that. Some of you attended the Court Cost Summit that my office helped to run last January. We had a couple hundred people there. It was reported in the Providence Journal. And the court, to its credit, ended up saying in January of 2020, yeah, you know what? They're right. Our judges have not been doing what the General Assembly told them to do in 2008, what you guys told the judges to do. So the problem of court costs, their impact on people, and their ability to reenter society and to achieve a successful rehabilitation is a real thorny problem that needs to be addressed, and if it isn't addressed, needs not to be made worse, which is what legislation like this would do. I just want to finish with I gave you some materials from this Conference of Chief Justices and the the National Conference of State Court Administrators. So these are some policies and procedures that, best practices, if you will, what we ought to be doing in these types of situations. Here are a couple of the recommendations that they made. I'll be real quick. One of the principles, it should be made explicit in authority providing for courts at all levels that while they have the authority to impose legal financial obligations and collect the revenues derived from them, they are not established to be a revenue-generating arm of either the executive or legislative branch of government. Another one of their principles says in part, while situations occur where user fees and surcharges are necessary, such fees and surcharges should always be minimized and should never fund activities outside the justice system. Fees and surcharges should be established only for, quote, administration of justice, unquote, purposes. Administration of justice, quote, unquote, should be narrowly defined, and in no case should the amount of such a fee or surcharge exceed the actual cost of providing the service. The core functions of courts, such as personnel and salaries, should be primarily funded by general tax revenues. So, again, while this legislation certainly is well intended, there are negative collateral consequences that flow every time we raise fees for defendants in criminal cases or, in this case, the folks who are going to the traffic tribunal in refusal cases. There's tons of data out there on this. I'm happy to make it available to you. I just gave you a small taste of it in what I've said here this evening and in the materials I provided you. So with that, I'll be happy to try and answer any questions that you might have.
Well, thank you, Mike. Great testimony as always. Do I have any questions from any of the committee members? Hearing none, that concludes the testimony on House Bill 5471.